Hello students, I hope you all are doing great. Today we will be understanding a very important issue about hijab. We all know that it surfaced in the news in the last month, right, on 9th of February, when few Muslim girls were being denied entry into the government PUC, right, pre-university college, right, in the district of Udupi, correct. And yesterday Karnataka High Court has come up with a ruling that hijab is not a part of essential religious practice of Islam. I repeat, Karnataka High Court has come up with the ruling that hijab is not the part of essential religious practice of Islamic religion, right. In this sense, the Karnataka High Court has upheld the order of the Karnataka government which bans the wearing of hijab in the educational institutions where uniform is compulsory, right. Now this has evoked mixed response across the territory of the country, and there are mixed feelings, there are diverse opinions with regard to this issue, right. Now here we will be understanding the issue and what is the essential religious practice doctrine. Let us begin with the session. Guys, Karnataka High Court yesterday said that hijab, which is a headgear or a scarf that is being worn by the Muslim ladies and girls in India and across the world, right. There are definitely different laws governing it, but Karnataka High Court has clearly said that hijab is not a part of essential religious practice in Islam, and where uniform is compulsory, you cannot have such attires or such clothes in the schools, right. In this sense, it has said that the right to wear hijab is not constitutionally protected, right. Guys, here we need to understand that Article 25 of our constitution, which talks about the right to freedom of religion, also gives a person the right to conscience and that of free profession, practice and propagation of religion. Article 26 talks about right to manage your religious affairs, right. Now in that, definitely the petitioners sought the protection of Article 25 and 26, saying that hijab is an essential religious practice of Islamic religion, and therefore it is a part, and therefore the girls wearing hijab must not be denied entry into the schools, right. Whereas High Court has rejected this petition and said that no Quranic injunction, that means it is nowhere mentioned in the Quran that wearing a hijab is religion specific, right. So they have Karnataka High Court has Chief Justice Ritu Raj Avasthi, right, and they may ask you the question with regard to the same. The present Chief Justice of High Court of Karnataka is Ritu Raj Avasthi, and the court has said that in Quran also the wearing of hijab is not religion specific. That means there is no mention of wearing of hijab in Quran, and that is the reason why they say that it is not a part of the essential practice in Islam. Therefore, in turn, in this sense, they have put a ban on hijab on the for the girls wearing it while wherever there is a uniform, right. Now, in this sense, they also said that the practice of wearing hijab is not adhered to. That means those who are not wearing hijab doesn't mean that the religion or the Islamic religion would lose its glory and cease to be a religion, right. So they have said that hijab is not an integral part of Islam. It is not an essential religious practice, and a girl who is not wearing hijab does not mean that the religion is diluted or the religion loses its glory or it ceases to be a religion. In this sense, it is kind of given its judgment upholding the Karnataka government decision over the hijab, right. I hope it is clear. Guys, before we move ahead, I'll explain you some articles or some constitutional provisions. Right to freedom of religion. Guys, we must understand that religion is the center of the societal existence of any human being, right? And it has played a vital role in the development of a society or civilization, right? And it has been so since time immemorial, right? Now, in Constitution, the freedom of religion is being declared as a fundamental right, which is definitely justiciable, right? And you have this article, as I've just mentioned, Article 25, which gives the person the right to conscience, and free profession, practice, and propagation of religion. Guys, here there are some parts or elements which we have to understand. Article 25 gives the person the right to conscience, that right of free profession, practice, and propagation. Profession means to profess something, some religion, right? Some ideal, professing some ideal. Then once you profess it, you start practicing it. Once you start practicing it, you may also propagate it, disseminate it, right? So that is called as propagation. And conscience is your belief with regard to the religion. So Article 25 is right to conscience and free profession, practice, and propagation of religion. And it clearly has put the restriction subject to public order, morality, and health. That means when you're practicing your religion, you're professing it, practicing it, or propagating the religion, you should not disturb the public order or the morality or the moral fabric of the society and the public health. Correct? At the same time, the state cannot be restricted in, going ahead with the social reforms of the religion. That means the government can do the social reforms in the religion. Guys, so this is your right to conscience and free profession, practice, and propagation of religion as mentioned under Article 25 of the Constitution. Guys, India is a secular state. India is a secular state. And by secular, we mean that there is no official religion of the state, right? That means there is no official religion of the state, and the state won't interfere into the religion of any person, which is his or her personal affair, right? So that means there is no official religion of the state, and state would not interfere into the religion, which is a personal affair of the person, right? Guys, secularism has two dimensions: positive secularism and negative secularism. What we practice in India is negative secularism, and what is seen in America is positive secularism. By negative secularism, we mean that the state would maintain a principled distance with his religion. I repeat, the state would maintain a principled distance vis-a-vis religion. That means it won't interfere into the religion until and unless it find any religious practice which goes against the ideals of the Constitution, right? That means the state would maintain a principled distance vis-a-vis religion, and it won't interfere into the religion until and unless it find any religious practice of the religion which goes against the ideals of the Constitution. For example, untouchability, right? untouchability was being seen by the court and by the lawmakers as something which is derogatory, something which goes against the ideals of the constitution, something which goes against the fundamental right of Article 14, that is right to equality, and therefore the state, interfered into the religion in order to eliminate this practice called as untouchability. And not only that, it also declared it as a fundamental right, that is Article 17, abolition of untouchability. Similarly, triple talaq was also, as it was being seen, it was a part of the Muslim personal law, and the court interfered in this practice and declared it a crime, right? So triple talaq was also being abolished by the court, right? So that means the state would interfere into the religion only when it sees that any religious practice is against the ideals of the constitution, right? So that is called as negative secularism, right? In this sense, the state also ensure the social reforms of the religion. Whereas in America, the state is completely, I would say, unattached to religion. That means it is completely indifferent of religion. The state in America does not interfere into the religion, and it completely do so, right? It does not interfere into the religion, which it thinks is a personal affair. Guys, the society in India is very different from America. We are much more diverse, linguistically, culturally, ethnically, religiously. We are much more diverse, right? So therefore, the state in India has to interfere in the religion in order to eliminate any evil practices of the religion. So I hope that we are clear with the concept of secularism. Guys, there is one more article called as Article 26, or I'll mention in the separate slide. So there is one more article. So as we have learnt, Article 25, there is one more article in the Constitution, Article 26. Now Article 26 talks about right to manage religious affairs. That means every religious community has the right to manage the religious affairs subject to public health, morality, public order, morality and health, right? That means the religious communities can manage the religious affairs. They can, start the institutions to manage the religious affairs. They can acquire the movable and immovable property. They can manage the property, right? So all these are mentioned under Article 26. If I talk about the previous cases, the Supreme Court has said that Article 26 applies to the whole religious community. That the community has the right to manage the religious affairs. Whereas Article 25, the court said, is applicable to individual. In this sense, the application of 26 is broader than that of Article 25. Plus, it also says that Article 25 in certain circumstances is subordinate to other fundamental rights. Whereas 26 is not subordinate to other fundamental rights, right? So we are clear with Article 26, which is the right to manage the religious affairs subject to public order, morality and health, correct? And we understood that the Supreme Court in the various cases have said that Article 26 applies to the religious community, whereas 25 applies to individual, right? 25 is subordinate to other fundamental rights. So whenever there is a clash between Article 25 and the other fundamental rights, the other fundamental right would prevail over Article 25. whenever there is a clash between Article 26 and other fundamental rights, Article 26 would prevail over the other fundamental rights. That means Article 26 is not subordinate to other fundamental rights, right? So that is the next issue. The third thing that we need to understand is the concept of essential. The next thing we have to understand is the concept of essential religious practice. Guys, those practices in the religion, in any religion, which is very integral to that religion, number one. Number two, if it is not being followed, the religion would lose its essence. The religion would lose its glory, right? You cannot practice, propagate that religion if that particular religious practice is being removed from that religion, right? For example, the court in many cases before has come that carrying of kirpans, wearing headgears, or you say turban, the pagadi that is being worn by the Sikh community, in the Sikh religion, is the essential religious practice. That means you might have seen that even if there is a uniform code in the schools, the Sikh people are allowed wearing turban. They are allowed to carry kirpans. They wear kadas, right? So because the court has identified essential religious practice of Sikh religion, absent them, the Sikh religion would lose its essence, would lose its glory, would lose its meaning, right? So therefore, in many cases, the court has come up with the essential religious practice doctrine. For the first time, the Supreme Court in Shirur Mutt case of 1954, the Supreme Court said that those practices which are integral to any religion would be called as essential religious practice, and it is the court which would identify that which all practices constitute the essential religious practice, right? So Shirur Mutt case, very important. But the problem in this judgment is that you are actually, giving the ball in the to court to decide what is essential religious practice and what does not constitute the essential religious practice, right? So that means you are in turn making the judiciary as a clergy. You are making the judiciary as a priest, as someone who would decide what is essential religious practice and what is not, right? So therefore, it is very problematic. This case was definitely problematic. Number one. Number two, in Anand Margi case, because Anand Margi, this was somewhere around 1984. Anand Margis are the people who, it's definitely a separate sect, and they do something called as Tandav dance. In Tandav dance, guys, they actually, carry the skull, the human skull, and they revolve around their shoulder, and in this form they kind of do this dance, and they believe that this helps them in achieving the trance, right? So it is definitely very sensitive when a person, carrying the human skull is revolving around the shoulder. It actually, gives the very wrong message to the society. So therefore, the Supreme Court in Anand Margi case in 1984 said that Tandav dance is not a part of essential religious practice is not a part of essential religious practice, and said that when Anand Marg was formed in somewhere around 1950s, the Tandav dance was not a part of its essential religious practice, was not actually the part of this religious sect. It evolved later, right? It evolved later, and because it evolved later, so therefore Tandav dance cannot be called as something which is a part of essential religious practice. Are you getting my point? So in this sense, again, it is problematic, right? So when the High Court, Karnataka High Court says that hijab is not a part of essential religious practice, why? Because it is not being mentioned in Quran. Guys, there are many religious practices which evolve over time, which evolve with the evolution of society, right? It is very much linked to the religion as well as the culture, right? So therefore, therefore saying that hijab is not an essential religious practice actually needs to be reviewed. Why? Because definitely hijab may have evolved later, right? But today, and when the court says that in the original Quran it is not mentioned, so the court has missed the point that there are many practices which evolve over time, right? So therefore, the case has went to the Supreme Court. It has been challenged in the Supreme Court, and definitely there are many other cases which are sub judice. We'll understand the other cases in the Supreme Court. I hope it is clear. So it's very important. Shirur Math case, Anandi Marg case. Guys, there are many practices in various religions, right? For example, if I talk about some religious practices in Sikh, as well I've discussed, they can carry kirpans, they can wear the turbans, and in the traffic law there is a clear exemption given to the Sikh people when they wear turban, pagadi. They are not supposed to wear the helmet, right? So that means they cannot wear helmet while driving the vehicle, because you cannot wear it on top of a turban, right? So in this sense, the state has interfered into the religion positively in order to identify the essential religious practice. It is said that in Hindu religion also, the case evoked a lot of controversies. Sabrimala case, right? We all know that in Sabrimala, the women of menstruating age 10 to 50 were denied entry into the Sabrimala temple in Kerala, right? The case went into the court, and it was being said by the petitioners that it violates Article 15, which is right to equality. It violates Article 15, which is prohibition of discrimination against caste, gender, so on and so forth. So therefore, it was challenged that it violates Article 14 and Article 15, correct? The court in the first instance held that definitely it is violating Article 14 and 15. So therefore, they actually, rejected this Sabrimala practice and made the temple open for all, for women of all age, right? However, it was challenged again, and it was sent again to a larger bench of the Supreme Court, and the case is still sub judice. Sub judice means still the judgment is yet to come, right, with regard to Sabrimala. Guys, it's very sensitive issue, right? Because now there has been deliberations and talks in the political circle, that if you decide upon Sabrimala, then all the other practices of various other religions must be, bunched together, and one decision should come and should be applicable to all the religious practices. It is very sensitive because the court would be deciding what is essential religious practice and what is not, right? In this sense, court is trying to act as a clergy, right? Guys, there are many other issues. There are many other religious practices. For example, in Parsi community, the Parsi women who marries a non-Zoroastrian, Zoroastrian is their religion of the Parsis. So Parsi women who marries non-Zoroastrian is not allowed into the sacred fire place in their temple called as Agyar. Again, it is discriminatory. Why? Because the women who marries a non-Zoroastrian man, a Parsi woman marrying a non-Zoroastrian man is not allowed in the sacred fire temple called as Agyar. Again, it is discriminatory as it violates Article 14 and 15. So again, the case is also there sub judice in the Supreme Court. Correct. Similarly, you all know, guys, in the Bohra community, there is a practice of female genital mutilation. There is a practice of female genital mutilation, where the clitoris of the upper vagina is being cut off in the Bohra community, and they believe that it actually, ensures purity, and this is derogatory, this is discriminatory. Why? Because it goes against it violates Article 14, 15, even Article 21, which is right to life and also right to privacy. Correct. So this female genital mutilation in Bohra community is also being challenged in the court of law, right? Again, in Muslim community also, there is practice of circumcision of the skin of the boys, the penis of the boys, right? And also in challenge in the court, right? So there are many cases, there are many religious practices of different religions which are being challenged in the court of law, right? If the decision on Sabrimala comes, if the decision on hijab comes, if the decision on Parsi community comes, that on Bohra community comes, and for Sabrimala, if the decision comes, the court is instead thinking that why not bunch all these practices together and then come up with one decision, right? Definitely, it is a very risky affair by the which the court has to come ahead with, right? So I hope you are understanding my point. So we have discussed in detail about the right to freedom of religion. Then we discussed the right to manage religious affairs. We talked about essential religious practice, and we discussed the Shirur Math case and the Anand Margi case. We also talked about Sabrimala, Parsi community, Bohra community, so on and so forth. I hope it is clear. Let us move to our slides. Guys, when the question was being put forth by the petitioner with regard to whether the prescription of school uniform is not legally permissible as being violative of Article 19 and 21, right? Petitioner said that it is violative of Article 19, which is freedom of speech and expression, and also privacy. But the court said that it is an established fact that the schools, in order to ensure the secularization of education, the uniformity of education, in order to ensure the discipline, the school authorities may make reasonable regulations governing the conduct of pupils under their control, right? So this is definitely, as identified by state, is a reasonable restriction, and in this sense the Karnataka government's order is right and it is being upheld. I hope it is clear. Guys, if the school uniform, see, because guys, we must understand that uniform is not something which is just limited to schools, but in defense, in police, in paramilitary, you do have uniforms, right? Here you cannot say that until and unless any attire is being declared by the court as a part of essential religious practice, you cannot say that you wearing them in the police and defense and paramilitary is upright, right? So until and unless the court does not decide what attire is the part of essential religious practice, it is not being allowed in the defense, police or paramilitary. Similarly, in the schools where the uniform is compulsory, you cannot, as the court said, that one cannot wear hijab or the scarf as it is not the part of essential religious practice, not found in the Quran, right? And it is not that if you don't wear hijab, you would, the Islam would lose its glory, right? Guys, if at all because again, as I said, that it has taken a communal turn where people from Hindu community, students from Hindu community also started entering into the school wearing the saffron scarf, right? Bhagwa scarf, right? So therefore, uniform is very much essential. If I talk about some Western nations, guys, because we must be not having a parochial view. We must broaden our mindset. We must, take the information coming from across the world. Guys, countries like France, which is a secular country, Sweden, Norway, Austria, Germany, and many other European countries have actually banned hijab. They have banned hijab, saying that it goes against the secularization of education, right? Because if every student start wearing their own attire, then there is no uniformity, right? And the uniform ceases to be a uniform, correct? And this in turn would establish a sense of social separateness, right? And thus in turn would offend the feeling of uniformity, right? I hope it is clear. Therefore, the court, Karnataka High Court, has clearly said that the Karnataka Education Act of 1983, which actually bans the wearing of hijab in the educational institutions, in the schools where the uniform is necessary, is actually upright and it's being upheld. Correct. I hope it is clear. Moving ahead. There was a beautiful article in Indian Express today by the Vice Chancellor of National Law University, Hyderabad, Faizan Mustafa. Now, he has given a balanced view about this judgment, saying that it is not the court who is to decide what is essential and what is non-essential religious practice. Because if the court start doing it, it would be acting as a clergy, right? He has raised many issues, many cases of the court and also the American Supreme Court, correct? It says that with this judgment, the High Court has proved that the discipline and control has a privilege over liberty, right? In this sense, guys, Faizan Mustafa has explored that the High Court judgment, Karnataka High Court judgment means that the discipline and control has a privilege over liberty, right? And this is something which is unfair, and in this sense the Karnataka High Court judgment also exposes the limits of the essential practice doctrine. Why? Because when the Sabrimala case is under review, it has been sent to a larger bench. It itself means that Supreme Court is also in doubt to actually identify what is essential religious practice. I hope you are getting my point. Let us move ahead. The author tries to identify the problem with the judgment. He says that religion definitely is the center of the human societal existence, and he also talks about the Sabrimala judgment, saying that it is already sub judice in the Supreme Court, the Sabrimala review, and this shows that the Supreme Court itself is in doubt with regard to the correctness of the essential religious practice and whether courts should assume the role of clergy, right? It also says that because the judgment of the court has said that the history of hijab is quite complex, because in the Quran there is no mention of hijab and it being the essential religious practice. It says that history of hijab is quite complex and has been influenced by the intersection of religion and culture. It may have developed with time, so as many other religious practices, right? So it is not necessary that a particular religious practice should have been, co-founded with the religion or should have been preceded before the religion came into being to be declared as an essential religious practice. Guys, definitely the Muslim women wear hijab out of either societal pressure, out of either, or is it a symbol of oppression? As the French court said once, that hijab is a symbol of oppression or societal oppression. Or there are many Muslim women who wear it by choice. So the Karnataka High Court order or judgment has actually ignored the question of choice, right? The choice, which is the right to freedom under Article 19. So definitely in this sense, it is the violation of Article 14, which is equality, Article 19, which is right to freedom of speech expression, and also Article 21, which has right to life and right to privacy interpreted under Article 21. I hope it is clear. Mustafa sir also explores that the freedom of religion under 25 has been subordinated and made subservient to all other fundamental rights. As we discussed that 25 is maybe made subordinate to the other fundamental rights in our earlier discussion. And in Narendra versus State of Gujarat, the court said that Article 25 has not been subjected to other fundamental rights. Right, Article 26 is indeed a group right, whereas Article 25 is an individual right, which we discussed earlier. Now that is your Narendra versus State of Gujarat case. Now in Shirur Mutt case, the court identified that Article 25 covers all rituals and practices that are integral to the religion, right? I repeat, all the rituals and practices that are integral to the religion are being covered under were being declared under Shirur Mutt case, and the judiciary took it upon itself to determine what is integral, right, and what is not to religion, right? We have discussed this Shirur Mutt case. Guys, at the same time, the assertion test of the United States was also being rejected, wherein the American Supreme Court has said that the plaintiff could just assert that means an individual would decide what is an essential religious practice. At the same time, the essential religious practice doctrine is erroneous and gives court extremely wide powers in purely theological matters, right? We have discussed Anand Margi case, and guys, see, in Anand Margi case also the court said that since Tandav dance was not originally part of the Anand Margi religious sect, so therefore it is not a part of essential religious practice. But we know that religions evolve with time. There are many practices which may evolve with time. So therefore, in that sense, if you say that if something is not mentioned in Vedas or Shrutis, then it won't be declared as an essential religious practice. So that is a very wrong theory, right? Because many practices evolve with time. Guys, in the recent Indian Young Lawyers Association judgment of the year 2018, where the court said that the foundation of the practice must precede the religion itself. That means the religious practice should precede the religion. That means it would be present before the religion came into being, or it was co-founded with the religion. That means it was co-founded at the origin of religion in order to be declared it as an essential religious practice. However, it is very problematic and it is under review in the Supreme Court, right? So they may ask you about the Indian Young Lawyers Association judgment also. I hope it is clear. At the same time, guys, in Gandhi versus State of Bombay 1954, the apex court held that no outside authority has any right to say that these are the essential parts of the religion, and it is not open to the secular authority of the state to restrict or prohibit them in any manner they like, right? In this sense, it is saying the court said that it is only the court which would decide what is a religious practice and what is not, which is again very problematic, correct? Guys, the High Court of Karnataka said that in the Holy Quran, the Holy Quran does not mandate the wearing of hijab, right? And it also said in its order that because there is absence of penalty or punishment or penance for not wearing hijab. Guys, see, it is not that if a Muslim girl is not wearing hijab, then he or she, I mean, she would be penalized, she would be punished. So it is not the case. Are you getting my point? So if the Muslim woman is not wearing hijab, she won't be penalized, she won't be punished, and there is no such punishment mentioned in Quran, right? So and that is the reason why they said that hijab is not a essential religious practice. Guys, Faizan Mustafa sir has explored another issue, that homosexuality, adultery are also haram, are also prohibited in the Muslim personal law. They are being prohibited in the Muslim personal law, whereas we know that section 377, section 496, that means adultery and homosexuality have been decriminalized in India in the previous Supreme Court cases, right? Adultery is no more a crime now, homosexuality is no more a crime now, right? Whereas homosexuality and adultery are haram or are a crime in Muslim religion, and there are punishments for doing the same, right? So in this sense, if there are punishments, then only you would decide whether it is a religious practice. Is very problematic and very vague, I would say, the way of looking at things. Are you getting my point? Because because there is a punishment for homosexuality and adultery in Islam, so would you declare that it is an essential religious practice? So therefore it is something which has to be explored. At the same time, the court has also explored that the author has said that it is a control model of administration, and and strangely the High Court of Karnataka has quoted the Rex versus Newport 1929 judgment of the US court about upholding of canning for smoking a cigarette outside school. In the year 1929, the Supreme Court of America has upheld that the students who smoke cigarette outside the school may be canned. That means may be beaten up by the teachers and the right. And in this sense, and it is very strange and surprising that the High Court Karnataka has actually has mentioned the court declared by the Supreme Court America under Rex versus Newport. The judges are not aware that there are schools that do not have uniforms, right? So in conclusion, guys, it is a clear setback to the liberty model of administration, and it depends upon the circumstances, right? Definitely the right to privacy, freedom of expression are being infringed, and then the case, the author also talks about the judgment has taken an extremely narrow view of the freedom of conscience and has demanded too heavy burden of proof, right? That means until and unless you are not able to prove anything in the court of law with regard to the essential religious practice, and that is what the Karnataka High Court said, that there is no enough evidence which to suggest that hijab is an essential religious practice of Islam. So they have relied or demanded too heavy burden of proof, and in this sense they have taken a narrow view of the freedom of conscience, profession, practice and propagation of religion, right? So a beautiful article in Indian Express, and I hope it is clear to all. That's all for today. I hope you enjoyed the session on the hijab row and the High Court ruling with regard to the same. Wish you all the best. God bless you. Good day. Goodbye.